bring in our guest to discuss this. Joining us now, National Trial Attorney Michael Jaafar is with us. And Michael Jaafar, I think it's easy for us to focus on the defense because the state seems to have such a strong case. So we're wondering, what is the defense going to do in this situation? And James Owens seemed to bring out things. I mean, he was even at one point able to get the pathologist on the stand to admit that it's possible being impaired from drinking made it difficult for him to use his hands while he was in the suitcase. And James Owens just almost casually said so he wouldn't have been able to open the suitcase on his own because of that impairment, getting in that insinuation to this jury that he had an opportunity to get out, but he had been drinking.
Yeah, I think he's doing a great job. I think the defense, I'm proud of my colleague for what he's doing, right? He took on this case essentially pro bono. I know she said she's going to pay him, but we all know she's not going to pay him. He's doing his case pro bono. He's doing a fantastic job. He hasn't even taken the case yet, the defense side, and his cross-examination has been very impactful. Also, last week when the witnesses came on, I kind of felt like the state was kind of laying the foundation for eventually the battered spouse defense. So I feel like this case could be going a lot worse for them. It's going pretty good. Sarah Boone, dude, she's on brand. I mean, I still think she should have taken the plea deal, but she's on brand. Her attorney seems to be towing the line, and they're attacking the prosecution's case. So far, so good. Early on, it's really early in the trial. A lot more trial to come. I still think that the state's case is, in my opinion, still overwhelming on the murder too. Definitely overwhelming on if they do a reduced charge to manslaughter. Like, I think that she's dead to rights on that. But, I mean, he's doing what he needs to do. Yeah, I didn't think about the fact that maybe Jorge Torres had a heart condition, and I didn't think about the fact that his level of inebriation would have contributed to him not being able to voluntarily open the suitcase. So, again, if I'm learning something, that means the jurors are also learning something. They haven't followed this case like us, but I'm sure they're thinking about this and taking note of the fact that, yeah, hey, he exactly was not a Boy Scout in this situation. Maybe he contributed to his own murder. Maybe it wasn't all her. So let's see what happens.
Does the work leading up to the defense case go out the window the minute she takes the oath and sits on that witness stand? And is that a concern?
Yeah, 100%. I just said that she's on 100%. This is going to be, in my opinion, the second most entertaining case I've seen in 5 years, right? Number one being the one in Massachusetts. So the minute she takes the stand, because all her interview videos, police interrogation videos with the pink shirt detective, right? All of them, they come in. I mean, we know she lied a lot. It got to a point where I think I was on TV with you, and she kept saying, I raise my hand and swear to the Bible I'm never going to drink again. So, like, all of that's going to come out. And when she takes the stand, we know she's the person who said no to a deal that would see her leaving prison with credit for time served in about 8 years, roughly, right? She's the person who said no to that. And she's the person who videotaped a man being asphyxiated in front of her in a suitcase. And I've also said that if any members of that jury are claustrophobic, I'm so claustrophobic I don't even get on elevators. So if any member of that jury, 2, 3 of them, are claustrophobic, and a lot more people are claustrophobic than you think, they're going to overwhelm the other members of the jury to say that's evil, that's torture. I would rather be burned alive than to be in that suitcase for a second. And I'll have nightmares even if she unzips me. So in my opinion, when she takes the stand, Ted, I'm glad you brought that out. When she takes the stand, everything goes out the window. The trial will just become what she says on the stand and how she gets embarrassed and ridiculed by the prosecution on cross. It's going to be vicious. I hope I'm here on the show with you guys. I hope I watch every minute of it, because that's going to be a vicious yet entertaining piece.
And it's already been promised, Michael. I know we've known it from behind the scenes, and I want to go back to that moment because the jury already has the expectation, and they're likely going to be thinking about it. Let's listen to the defense attorney laying it all out in openings. Michael, that word will, she will testify. It's one thing to tell the public, it's one thing to tell the court outside the presence of the jury that she's planning to testify, she will testify, but once you say it to a jury, there's almost no turning back.
She's getting convicted if she doesn't take the stand based on that. You're correct, Julia. When you are doing your opening statements, you are creating credibility points for you to follow up on, right? We all know that a state or a defense attorney, if they say something in the opening statements and they don't produce it during the case, they lose credibility. It has happened many times in many cases. So we now know that she is going to testify. This is like the analogy of an airplane. Once it reaches, I think, V2 speed on a takeoff, it can no longer safely abandon the takeoff. It's got to take off. Right? That's where this case is, and that's where the decision of her testifying is. She cannot turn back. And honestly, I'm not shocked. This is one of the instances where I wouldn't have wanted her to testify if I was able to keep out the interrogation videos. I know they couldn't because of the fact that she lied. But in his opening statement, he also said, my client lied. He used the word lied, which I think that was a little bit too much, right? There's another way of phrasing it, but he said she lied. So he's getting the jury ready and conditioned for her testimony, and he's saying to them, look, they're going to cross-examine her, and they're going to say she lied. I'm telling you that she lied. You don't have to wait for that. Well, don't wait for the camera. She lied. She was nervous. She was talking to police. It was 2 hours. She didn't think that she could leave. So at the end of the day, and we know they filed a pretrial motion to try to keep it out and saying that they didn't redirect. So we know that they believe that his client has convinced him, I'm a victim here. Everybody else is wrong. I'm right. So I've been in those meetings. I know the meetings when you're with a client who thinks that they are the victim, but too much so, and she has controlled. She fired 8, 9 lawyers. So I know how she got to this point. It's by telling her lawyer, you want to be my lawyer? I want to testify. I didn't lie. It wasn't my fault. It was done. So that's why I'm going to be so entertained to watch her testimony.
Yeah, the other caveat was, and I'm not taking a deal if you're my lawyer, I'm sure, because the other 8 were like, take the deal, take the deal. All right, let's get a break here. An issue there with the video. Michael Jaafar watching along with us. This case, boy, it is something else. The fact that the defense continues down this road of the brothers did it, the jury was able to watch both of the brothers take the stand, and they'll be able to make a choice themselves. Is there reasonable doubt, do you believe, here for Melody Farris, because there are so many unanswered questions? Let's face it. You know, the 300-pounder on the burn pit, how did he get there, and no murder weapon?
I think there's an orb of reasonable doubt, massive orb of reasonable doubt that cannot be moving, no pun intended, because of the weight of Melody Farris versus Gary Farris, right? In the closing arguments, I would have a very condensed, this is a very condensed version of what I would say over an hour. I weigh 200 pounds. I cannot move 600 pounds. Whatever you weigh, members of the jury, imagine yourself being able to move 3 times that. The strongest Olympic weightlifter can only bench press twice his body weight, right? Nobody can do more than twice. So unless you think she's basically Iron Man, there's no way she would have murdered him in one part of the house and moved him to the burn pit. It's not physically possible, right? Unless she had a lot of help, and that's not even the state's theory. Whereas his son, who's a farmhand, who's a big, strong buck, who also had the financial motive to do it, could in fact theoretically have done it. There's no way my client would have done it. So I think there's a lot of reasonable doubt. If the jury still convicts this person, and I'm not saying they'd be wrong to convict her. I'm also not saying they'd be wrong to acquit her. But if they convict her, in my opinion, in my humble opinion, it's only because of the fact that they developed a hatred of this woman, right? This woman, according to Matt Johnson, doesn't even stand when the jury comes into the room, which to me was bizarre. It was disorienting to even think about. If I was her attorney, I wouldn't have done this in front of the jury, but I would have taken her aside in the hallway on a break, had a stern conversation with her. If you don't stand the next time the jury comes into the room, I'm walking out, I'm quitting the case, right? I'm going to file an oral motion to withdraw, right? It's that disrespectful, her behavior in the courtroom. So if she gets convicted, in my opinion, that has to have been a massive part of it. So yeah, I do think there's reasonable doubt, Ted. I do think there's reasonable doubt. Will it carry the day? I don't know. It's a tough one.
So these jail calls that are happening right now, just to clarify for our viewers listening along, it's Melody talking to her daughter, Amanda. This is a daughter that we've heard from the other siblings that fully supports her mother. We haven't